In this case, the other side, the insurance company, has elected not to present oral argument. So you'll be the only one presenting argument this morning. You'll have 15 minutes to make whatever points you would like to us. And after that, we'll take the case under submission and issue a timely written decision. So with that, you have 15 minutes and you're free to make any arguments you'd like to. We may ask you a few questions.
Okay. First of all, I had a lawyer lawyer Bender, I'm sorry, filed let me see, it was the proposed findings of facts and conclusion of law. Well, he filed that motion for me on March 8th, 2021. And he filed it on time, which is dated on time, and the timing is on time. It was March 8th, and it was filed at 11:14 in the morning, but the judge ruled it out of time and dated, and the date on the filing was February the 8th, 2021. So in the case where the dates were all confused, and also it was stated that it was out of time when it was not in time. So my motion was not allowed in court. It was never heard. And so I filed a motion to the appeals court, a brief stating that let me see, stating that my what I'm telling you now, what happened, where my case was not allowed in the court when it should have been, because it was on time and the dates were different, because the judge made the ruling on let me see what on her attorney's the judge's decision was on let's see, I gotta get these papers straightened up. It was in November, no, it was in February. Let me see. Trying to get. She made her ruling, her judgment on February the 26th, 2021. So they went all the way back to February and ruled my motion out of time, which it was March at the time that it was filed. So everything was just confused and out of order. And I was explaining this in my brief, which I had to write myself, because at the time I didn't have a lawyer. I couldn't afford to get another lawyer. I didn't have the money to get another lawyer. And also in the hearing that I had, where the American General, the company, had said that my policy had elapsed on April the 26th, April 2016. That was not true. It had not elapsed because they had received the payment. And the judge found that she found in favor of me that I had made all my premium payments, that I did not miss any, but they were saying that I missed one in April, which elapsed me.
Right. So, and I guess maybe the question was, I thought the court agreed with you, as you were saying, that you had made the payments, but then the American General reinstated the policy at a particular time. And so that's why the court was saying, hey, like, you got the relief that you wanted.
No, they did not reinstate it. See, that was the problem. They did not, they said in the at the hearing that they had reinstated my full policy of $10,000 in July of 2019, and that was not true, because in the letter that I was not able to present in court from the lawyer Goldenberg, lawyer Goldenberg, what they were trying to do was give me a face value of $1,636.60, and they would reduce, and they said, would you now reduce my face value to $3,040? And I never agreed to any reinstatement of that sort. But they told the judge that they had reinstated me and I missed the payment. That was never the truth. That was never the fact. I never agreed on anything with them because they were not going to give me the $10,000 face value. They were only willing to give me $3,040, but they told the judge something different. And they never reinstated me, and I never missed a payment because I never made another payment. After we went to
was the policy a $10,000 policy? Is that what you're saying?
Yes.
Okay.
And they never reinstated that full value, but they told the judge at the hearing that they did reinstate it, and that is not true because I have the letter here stating what they were doing and what they did do, and I didn't accept it. I told them that I'm not going to do this because my policy should have never lapsed because I did not miss any payments.
So wait, are you saying that they did not offer to reinstate the policy, or are you saying that they offered to reinstate it but you didn't want to accept it?
No, they want. Oh, see, this is what happened. They want. I had a $10,000 policy. They were supposed to reinstate the policy for $10,000 because I never missed a payment, but they did not want to do that. They wanted to reduce the payment, the face value of the policy to $3,040.
That was due to loans that were outstanding?
It wasn't no outstanding loans. I had some premium loans that were taken out. Like when I was sick and wasn't able to work and I got laid off, the premium loans were taken out. But at the time, when you get a premium loan, that would be taken from the face value of your policy just in case you was not able to pay. And that was the only loans that they never proved any of it. They stated that I had loans, but there was no one in court to prove that I owed those loans. They just had something stating that I owe those loans. I never had signed any paper. I asked them to give me copies of signed papers where I signed for those loans, and they never did do it. The ODI asked for signed documents where I signed for loans and had received them. They never did do it. They said they couldn't find them because they couldn't find them because I never did get those loans. I tried to get a couple of loans, but they rejected them. They didn't ever give them to me.
Ms. Washington, is this policy still in effect as far as you know?
No. After the judge ruled, I never heard anything else from them anymore. It's like they just took, for 20 years, I paid them money. For 20 years, I had, actually, I had paid $10,000 into that company already because I was with them for 20 years. So they already had received the $10,000 already. So they didn't have to worry about it.
Ms. Washington, I may be wrong on this, but isn't this a life insurance policy? Is it a life policy?
Yes, it is.
Okay. All right.
And out of 10,000 years, Your Honor, I was paying $41.59 every month. They had already received the $10,000. So what did they have to lose? I'm the one that's losing because now, at my age now, which 20 years later, to get a $10,000 policy, I would have to pay. I have a document here stating that I would have to pay twice, almost 3 times as much now, just to get a $7,000 policy because of my age now. So I have the paperwork here stating that at my age now, what it would cost on my policy. And this is what I'm saying. They didn't consider me at all. They, even though they knew that I had made the payments, sometimes they were late, but they were made. So I was trying to find the paper where, let's see. Lawyer Bender had did the research for me to present to them in his motion in the proposed findings of. Let's see, I'm trying to find it. It's somewhere in there. I have so much stuff. It's been going on for so long, and I'm like, let's see, where is it?
We have all the documents that were filed at the trial court, so we've got copies.
You don't have how much it would cost now for me to get that same $10,000 policy. It would be almost three times as much now than it was then. So that's what Lawyer Bender was trying to establish. And I have a chart here. I have a chart
Your
here.
your main argument is that you disagree with the magistrate's determination that the policy was in fact reinstated. You're saying that the policy was never reinstated.
It was never reinstated.
But if the policy had been reinstated, would you agree that then you wouldn't have any damages?
I would agree. I probably would have, I probably would have agreed if I didn't want to, because of what they had put me through. But in essence, to my age now, to get just the $10,000, I probably would have said, well, wait a minute, let me think about this. Because if I try to get the same $10,000, it's going to cost me much more. If they had reinstated the full value, the $10,000 face value, but they didn't want to do that. They wanted to give me $3,000.
Because they were arguing there were outstanding loans against the policy, right?
But
You're disputing.
I'm telling the truth. There was, and Lawyer Bender had did the research in his motion that they never had anything to say that I had received those loans. They were saying that because I had got some premium loans. I did get a $200 loan, but that $200 loan was to pay up where I had fell behind. It was not for anything else. Every loan that I received for them was because I fell behind in my premium payments. It wasn't because I was trying to get a loan. And like I said, and I repeat, the loans that I tried to get, they denied them. I did try to get some loans, that's true, but I never received them because they denied them. I asked them to give me signed copies of where I signed and received the loan. I never got them. They told the ODI and the judge that they were outdated and they couldn't find them anymore. But yet they found a $200 loan, and it was around the same time, but they couldn't find all that other money that they claimed I had received, the $3,000, because I didn't get it. I didn't get $3,000 from that company. I'm telling the truth. They never let me have any money like that because I was already struggling trying to keep my policy in effect. So they never let me. I never had enough. I never had enough money in my cash surrender value, whatever, cash surrender where you can get money. I never had enough in there to even get that kind of money. So I don't know why they would put me through this out of 20 years and saying that I got that money and I didn't get it. I tried, but they denied me. Every time I would try, they would deny me. That's the truth.
Well, Ms. Washington, we appreciate your argument today. You're at your time.
Did you want me to send you copies of where they wanted to offer me the $3,000 face value, and I said no because
no, ma'am. Because like I said, we have everything that's in the trial court record. We have, and if it's outside of the record, it's something that we can't consider at this point in time. So we'll make sure to review everything to find what you were talking about. And we will take this matter under submission. And like I said, we will issue a timely written decision and we'll send you a copy of that decision.
And Your Honor, I wanted to say this because I can't really explain myself the way our lawyer Bender would have done if he could have gotten the motion into the court. But by him not being allowed to get this information on the proposed findings of facts, that he had written for me, that some of the information that he had is never going to be known because he wasn't allowed. My motion wasn't allowed. The judge rendered it out of time when it wasn't out of time. I don't know why they did that to me, but I guess it was just an error that that happened. But even after the error was brought to their attention, they still didn't do. That's why I filed the appeal, because I wanted to be treated fair. I wanted to be considered. I didn't want to feel like, you lost and that's the end of it.
No, we appreciate that. We appreciate your arguments today, and we'll get a decision out as soon as we can and make sure you are informed of it.
Okay, thank you very much for the opportunity. I have never did this before, and I'm a little bit shaky, probably a little bit.
Oh, you did great. You did great.
Thank you so much. Thank you all.
All right. Thank you. Have a good day.
You too. Bye-bye.
Hey, good morning.
Good morning, Mr. Evans. The last case today is Scott D. Wells, and you're here on behalf of the appellant. It looks like the appellee has waived oral argument, so you have 15 minutes to tell us whatever arguments you'd like to.
May it please the court? Your Honor, I just want to let the court know, to put it on the record, I really wanted to submit on my brief, but in this case, there was no opening statements. There was no closing arguments. There were no witnesses being called. And if you look at the transcript, I even asked the trial judge at the time, like, hey, are we going to have a chance to, call witnesses? And he's like, I don't think that's necessary. So with that, can
I ask you, did he swear the witnesses in? Because I didn't notice in the transcript that the witnesses were even sworn.
No, Your Honor. He essentially came and just said, let's just talk about it. And I'm like, well, I'm prepared to have a trial. So procedurally, it was not done properly. We never were really given a trial, and I will just close on that.
Well, let me ask you one question before you close, and that is, like, did you make any type of proffer in terms of saying, like, hey, Judge, we need this witness to testify about this subject or something like that?
Well, when I talked to the judge during the trial, what I said was, we have witnesses that can prove something about this dog, and he said, he responded, I don't see it that way. So and we went from there, and he said he was going to give us a decision.
So wasn't the major dispute on the breach of contract? The issue was whether there was going to be, in addition to selling the dog to your client, that your client would be trained on how to use the dog.
Correct. That was the crux of it, because if he wasn't learning how to use the dog as well, the dog was just another dog to him. And the opposing party is saying that his the deal was just the dog, but we never really got to get into that or really give
Well, there
any
were
evidence.
there were two contracts that were
Right.
submitted, right? There was
Right.
one contract submitted by the appellee and
Right.
one contract submitted by your client, and
Correct.
they differed, right?
Correct.
And so there was a dispute over which was the real one.
Correct. And I, as just being the attorney here, you know, my client gave me the contract. I proffered it. He said it's the real one. He says his is the real one. That's really for the finder of fact to determine which one is authentic.
Okay. And then you had counterclaims as well.
For breach of contract and really, yeah, it was a breach of contract counterclaim.
So if this had been a trial, how would you have imagined things have gone differently? Because to me, reading the transcript, the judge questioned both sides. You were allowed to argue. What would have been different besides the witnesses being sworn?
Well, I think I would have been able to get some more evidence in. We had a couple witnesses that had very close relationships that were at the deal, that heard the things that happened, things of that nature. So we might have been able to.
You had other witnesses that were prepared to testify?
Yes. And
were those witnesses present?
Yes. They were present.
Okay. Yep.
Okay.
Okay, were there any further questions?
Oh, no further questions. Thank you guys for your time today.
Okay, thank you very much. We will take the case under submission and get a timely written decision out.
Thank you so much.
All right, have a good day.